Welcome to Jury Charge and Literary Practice. We'll get started with this jury charge. Ready? Here we go. The amount of bail must be reasonable in light of the crime committed, the person's criminal record, and other factors. When a person has no prior convictions, bail may be waived. When a person is released on his or her own recognizance, all that is required in this case is his or her promise to appear in court at a later date. Ordinarily, he or she will be released on his or her own recognizance only when the crime is not serious, when he or she has no previous criminal record, and he or she has lived in the area for a substantial length of time. When someone is formally charged with the crime, a criminal complaint is signed by the arresting officer. The complaint is reviewed by the district attorney's office, and if it feels it is justified, the complaint will be filed with the court. If someone is suspected of a felony, he or she must be charged either by a judge after a preliminary hearing or by an indictment issued by a grand jury. The purpose of each procedure is to determine whether there is sufficient cause for charging the person with a crime. A grand jury is a group of individuals who are appointed to review cases to determine whether crimes have been committed. A person selected for a grand jury usually is selected for a longer period of time than a juror for a trial jury. A preliminary hearing is held before a judge or magistrate. The judge or magistrate decides whether there is enough evidence to hold or bind the person over for trial. At the preliminary hearing, the person can have an attorney represent him or her. The attorney can cross-examine the witnesses called by the district attorney. The judge will order the person to stand trial only if the evidence shows that it is probable that he or she committed a crime. In a grand jury proceeding, the district attorney presents a document called an indictment to the grand jury. A panel of people selected from the local community. The grand jury has the power to subpoena witnesses to appear before it and can consider just about any type of evidence it wants, including evidence that may not be admissible at a trial. Sometimes, after a person is arrested, the district attorney may be willing to plea bargain. Plea bargaining is an agreement between the prosecution and the defendant in which the defendant agrees to plead guilty to a crime in exchange either for the prosecution dropping a more serious charge or for a less than maximum sentence. Parents and school teachers are generally entitled to use reasonable force to discipline their children or pupils without being criminally liable for assault or battery. All right, let's get back to our literary material, our article about writing the Republican National Convention. And let's see, we're on the second to the last question. So we have two questions and then we'll be finished. So see what they have to say. Ready? Who was the most interesting person that you met or saw if you didn't get to actually meet anyone? D. My room was filled with legislators from the West, where I am from. One said we were the Western Caucasus, Idaho, Oregon, Wyoming, and Utah. I was the Utah. They were including me as one of them. Your attitude can immediately create liaisons and bonds. They will remember your contributions and the value you brought to what is important to them long into the future. St. Many of the top politicians in the party were present, of course, but it was a very busy place, as you might imagine. Someone escorted us to our respective rooms, and the participants were quite busy until the moment the meeting started, so there was not a lot of opportunity for interaction. It wasn't a place that you could just stroll the hallways and observe the process. It was a very controlled environment for sure, but I'm happy to have had the opportunity to be part of the process. What advice would you give to people who would want to develop the skills to do a job like this in the future? D. Start today preparing yourself to be available and to produce the fastest, most accurate, and invaluable product you can. St. You can start by making yourself available for difficult assignments. I think we all become comfortable in doing the easy stuff. Who doesn't want jobs that flow through quickly and painlessly? The inherent problem with that is that you may not be developing your skills to their maximum potential. An agency covering an assignment like this needs to know that you're competent to handle it. If you've covered difficult things before, you're more likely to be trusted with their top shelf work. All right, let's get back to some jury charge practice. Ready? For you to make your decision, you must understand what is meant by proximate cause. The proximate cause is the immediate cause. While the defendant may be a part of the cause, the defendant may not be the proximate cause. There is a difference. When the defendant admitted liability for the accident, the defendant did not admit liability for being the proximate cause of the accident. In the law, you must make that determination. A plaintiff who is injured as a proximate or legal result of some negligent conduct on the part of the defendant is entitled to recover for such injury. Thus, the question for you is to determine whether this fits this case in question. You must examine whether the conduct of the defendant was negligent. You must also examine whether this negligent conduct was the only conduct that caused the accident. If it was the only negligent conduct, then you must consider this in your decision. With regard to liability, you must know that negligence must also be considered on the part of the plaintiff. You must examine whether the conduct of this individual was in any way responsible for what happened. A plaintiff who was injured as a proximate or legal result of some negligent conduct on the part of a defendant is entitled to recover just compensation for that injury from the defendant. You must decide what is to be recovered. Thus, the plaintiff is entitled to a verdict in this case. If you find that the defendant was negligent and that such negligence was a proximate or legal cause of injury to the plaintiff, you must decide what the plaintiff is entitled to recover. For this reason, you must know and understand the meaning of negligence. It can be the failure to do something which a reasonably prudent person would do under circumstances similar to those shown by the evidence. You must determine whether this applies to the defendant. You must determine whether the defendant acted in a way that was negligent or whether the defendant acted in a way that only was a part of the negligence that was involved. Liability may be on both sides. For this reason, the liability of both parties must be considered. All right, now let's move on to another article in our Journal of Court Reporting, and this is called Writing the Democratic National Convention. It is by Susan Simonelli, Ciminelli. Ready? Since 1996, Alderson Reporting has been closed captioning the Democratic National Convention on site. There are many challenges and frustrations, but always exhilaration. The opportunity has been an honor, a privilege, and an absolute career highlight. We were not only captioning the conventions, but our captions were proofread and turned into the official convention record on a daily turnaround. Alderson had been tasked with reporting the official record for years, so captioning was a natural fit to enhance the production of this event and provide accommodation to those who depended on it. We reported pre-convention committee meetings, mostly the Rules Committee and Credentials Committee. The hearings were challenging to report, but they were generally very short, until 2016 anyway. The convention is a gavel-to-gavel production governed by parliamentary procedure. While the public sees an hour or two in prime time, we captioned 6 to 8 hours every day. The week starts out with 5-minute speeches by less important people and ends with the big crescendo of nominating the presidential and vice presidential candidates. The process is 4 days long. Imagine how many speeches, speakers, and topics we have to prep for. Our dictionaries have to contain the party leaders, all members of Congress, the Supreme Court justices, celebrities and VIPs, and 4 years of past and current events. It takes a village. We were lucky to have an amazing support team that understood what we needed to succeed. Our technical and support staff through the years, Amy Durr, Rob Dezel, Chris Gaskell, Chris Kopek, Ira Sharp, and Rose Ann Sharp, our mini proofreaders, our scheduling guru, Joe Bradley, always had our backs. They ensured the encoders, teleprompter feed, and audio ran smoothly. They secured the daily agenda, oodles of speeches, tracked down our daily credentials, waited in horrendously long lines for food, found the closest bathrooms, put up with our grouchiness, took photos for us, and literally massaged our backs. We started out in 1996 needing a multitude of support staff, but by 2016 our well-oiled machine only needed one. This article on the Democratic National Convention is a little bit different. It's because it's just by this, I believe it's by just this one person, and she was captioning it. So that's a little bit different, and it's good to get her perspective on that. Okay, let's get back to some jury charge. Ready? If, however, the punishment is excessive and the child is injured, the privilege is lost, and the person is liable for assault and battery. The use of deadly force to discipline a child is never permitted, and if deadly force is used and a child dies from it, the person can be guilty of manslaughter or even murder. A person who is acquitted of a particular crime cannot be tried a second time for the same crime. If the state tries to prosecute a second time, the defendant can assert the defense of double jeopardy. Another procedural defense is that the statute of limitations has expired. In other words, the crime has run out and it is now too late to prosecute. Most crimes have a time limit on how long after the crime charges can be filed. Due process means that before you can be fined, imprisoned, executed, or otherwise punished for a crime, the government must respect your rights. You are protected and have the right not to incriminate yourself. You have the right to be free from unlawful searches. You have the right to retain an attorney or have one appointed for you free of charge if you can't afford one. You have the right to confront and cross-examine your accusers. All right, let's read a little bit more about the captioning the Democratic National Convention. Ready? We didn't know what level of access our credentials provided until we were on site each year and occasionally from one day to the next, our level of access changed. We had new security perimeters, new procedures, new technology, new offices, and new challenges. One of our biggest challenges every year wasn't court reporting at all. It was how we'd get from the hotel to the convention location and how long it would take to get in, find our office access, and get into our seats. Once in the convention facility, we worked in a tiny office that was usually quite warm for at least 10 hours every day without leaving. This is where we learned how to pack a to-go bag should we ever get stranded on a desert island. There were, however, some constants that didn't change. Our workroom was always close to the backstage entrance. Good for us, as we saw celebrities and VIPs pass through the halls all week. We almost always had a teleprompter feed in our office. With the exception of the eloquent Reverend Jesse Jackson, almost every speaker would follow along nicely, making it easier for us in case we didn't have their speech ahead of time. We were always very close to the speech intake office, and we usually got them all. I'll bet sometimes only 10 seconds before they were spoken. We did a lot of finger spelling. All right, on that note, that will conclude our literary and jury charge practice.